AB 1836. Thank you, sir. Please proceed.
Thank you. Good afternoon, Mr. Chair and members. Today I present AB 1836. This bill would serve to get individuals with severe mental illness that are often overlooked by current law the help and treatment they need through an LPS conservatorship. Under current law, only a professional from a county agency or facility providing treatment or evaluation services may make a recommendation to the conservatorship investigator for an LPS conservatorship based on specific findings of an individual's level of disability. If an individual is not receiving treatment or evaluation from the county, no such recommendation can be made and no LPS conservatorship may be contemplated. At the same time, the probate code governing traditional probate conservatorships only allows for treatment of a conservatee in a secured facility or involuntary administration of psychotropic medications where the conservatee has a diagnosis of dementia and not for any other mental health diagnosis, no matter how serious. AB 1836 would simply allow a judge presiding over a probate conservatorship to recommend to the county investigating officer the establishment of an LPS conservatorship where there is evidence of grave disability as a result of a mental disorder and make associated procedural changes necessary to carry out this authority. This bill is very similar to last year's AB 193, which was supported by the committee and unanimously supported in both houses, but vetoed by the governor. In his veto message, he stated that 193 bypasses the clinical expertise of county professionals. Although 1836 does not require the evaluation by county mental health professionals prior to the investigation recommendation, there is currently a requirement for prior evaluation or treatment by a licensed provider in the bill, similar to the existing county requirements. My office has currently been in discussions which are going well with the governor's office to alleviate his concern, and I believe we will come to an agreement very soon. Thank you for your time and the opportunity to present AB 1836 this afternoon. I have with me Larry Doyle from the Conference of California Bar Associations, and I would respectfully request an aye vote.
Second. So we have a motion and a second. Your witness, please.
Good afternoon, Mr. Chair and members. Larry Doyle on behalf of the Conference of California Bar Associations with the sponsors of AB 193, or we were the sponsors of AB 193. We're now the sponsors of AB 1836. As Assemblymember Mainshine indicated, we are working with the governor's office and with others who have expressed concerns with the bill as it moves along to ensure that it's clear the requirements for evaluation that must take place before a patient or an existing probate conservatee could be recommended for LPS conservatorship, and to tighten things up generally to address those concerns. We think it's going to be a better bill when it gets to the governor's office this time, assuming that we can get the support of the committee as we had before, and we ask for your aye vote.
Okay, thank you very much. Any other witnesses in support? Okay, seeing none. Witnesses in opposition? Thank you.
Good afternoon, Mr. Chair and members. My name is Farah McDade-Ting with the California State Association of Counties, representing all 58 of California counties. We are regretfully here again to oppose this bill, which is substantially similar to last year's AB 193, which we've all talked about was vetoed by the governor. Our main concern with the bill, we have our public guardian folks and our mental health professionals here as well, but our main concern with the bill is it would allow a different door for people to be recommended for an LPS conservatorship. It would allow a judge to recommend somebody for an LPS conservatorship. Currently, only a clinician or medical professional can do that, and we feel that that is the proper and right route for a person to be recommended for an LPS conservatorship. We do want to work with the author, and we've worked well with the author and the sponsors on this bill, and we're looking forward to talking about more issues. The author is committed to ensuring that people get the mental health provided service that they need at the right time, as are we. So we're hoping to come to some sort of workable solution that may not involve conservatorship, but I think what Assemblymember Mainshine sees in our communities is people that need treatment. And as the county providers, we want to be able to provide that treatment when necessary. So we do agree on that. I am also today representing the urban counties of California, and I would want to thank you for the time to allow me to testify.
Very good. Thank you.
Mr. Chairman and members, Trent Smith, representing the public conservators and public guardians. Our clients are the employees who are county employees who are asked to both do the investigations and then provide the services under the conservatorship. And just as a reminder, as we've said for the last couple of years on this issue, these services, conservator and guardian services, are fully funded by the county despite the various mandates that the state imposes on conservators and guardians. There is no state reimbursement. They're already strained to provide the work, as you might imagine, with the mental health crisis that we have in our communities. So this is yet another investigation that they would have to do without reimbursement. I think it's also important to understand that even if they are put into an LPS conservatorship, one of the biggest problems we're facing right now is the conservators, our clients, don't have any places to put these people. There are not enough beds throughout California in treatment facilities. So that's one of the things that we would like to discuss as a broader approach to some of the concerns that we share with Assemblyman Manshine. And the final thing I just point out is that an LPS conservatorship is a pretty serious process. You're taking away a person's fundamental rights and usually putting them in a locked facility. And so when you are talking about an extreme measure like that, we still think it is a good idea to have the medical professional standing at the front of that line making that determination rather than a probate court judge.
Thank you.
Good afternoon, Mr. Chair and members. Adrienne Schulten, representing the County Behavioral Health Directors Association. We represent the public behavioral health authorities in counties across the state. We are regretfully opposed to this bill. The reasons so eloquently stated by my colleagues here, but the bottom line is this bill circumvents the established mental health system for LPS conservatorships, and there are certain protections and due process right afforded to these individuals in our system. And we feel that these are violated under this proposal. So we look forward to working with the author's office to come up with a compromise on this legislation. Thank you.
Thank you. Other witnesses in people in opposition, just your name and organization, please.
Linda Kincaid, daughter of Carol Hahn, who was a victim of horrific abuse by a court-appointed conservator. I oppose any additional authority to conservators when there is no oversight and no accountability for abuse.
Thank you. Name and organization only, please.
My name is Jennifer Warner. I'm a licensed mental health professional, and I'm the granddaughter of a 100-year-old woman who was isolated and mistreated by her court-appointed conservator. Thank you.
Once again, name and an organization only, please.
Nicole Wortelman on behalf of the Ventura County Board of Supervisors in opposition.
Thank you.
Richard Calhoun. My family was out of San Bernardino County where this came from. We're completely opposed. A 90-day conservatorship has lasted for 6 years.
Thank you. Questions or comments from the committee?
I won't be supporting the bill this year. I didn't last year either. I come from a county board of supervisors seat, very aware of the intense process that the county employees are going through in terms of their investigation and just the number of cases that they are handling. I don't disagree with the fact that we have a tremendous need out there, so it's more about how do we actually meet the need. I'm in complete agreement that mental health professionals have to be involved in this process. So I'm glad to hear, Assemblymember Manshine, that you're continuing to work on the bill. I hope we can get it to a place where the counties can be in support. This is a very important safety net function that they perform, and it's very, very important that they come to a place of agreement on the bill. Thank you.
Anyone else? Mr. Turman?
Thank you, Mr. Chair. I wanted to ask a question to some of the witnesses who spoke in opposition. I just want to say right out, I do share the concern. This, conservatorship to me is not an issue to ever be pursued lightly. But having said that, I've met with a number of family members of individuals whose mental health needs had become so severe, and conditions so severe that the family members in my district came to me this fall to talk about this issue and asked us to give some leeway to pursue conservatorship. And I know it's a very contentious issue that I think should always be looked at on a case-by-case basis and really as a case of last resort to make these types of decisions for someone. And so when you say that a probate judge shouldn't make the decision, I guess I'd ask the question that if there are circumstances that show someone, a consumer, there are circumstances that warrant it, wouldn't the judge still have to, like in the normal procedures for conservatorship, take a look at what those conditions are, including the mental health needs of the individual and what their current circumstances are?
Thank you, Assembly Member. I'll try to answer the question. So there's two systems for conservatorship. There's the probate conservatorship process and then the LPS conservatorship process. Probate conservatorship, people can arrive in that process through a number of doors, and the probate judge presides over that process. The LPS conservatorship, because of the fact that you're essentially revoking the conservatee's rights to medication. You may put them in a locked facility. You're taking control of all of their affairs. It's a very, very high bar. And that is the reason why a clinician needs to first say that this person does have the grave mental health needs that you described. What we say is that someone who has that type of high-level mental health needs will touch the mental health system, and a clinician will assess them and can make the recommendation for LPS conservatorship. What this bill does is has the people that are on the probate side of conservatorships, which again is a lower bar of conservatorship, and a judge seeing that they may have mental illness or, often cases, severe addictions, things that are affecting their ability to take care of themselves. This bill would allow that judge to refer them. What we would say is that person, if they are in crisis or have a severe illness, will either be through their primary care doctor, through the Medi-Cal system, or a number of other doors. They will see a clinician, and the clinician can make that determination. This would bypass the clinician and allow the judge. It is true. The judges have many people in probate court standing before them that they think would qualify. But that person needs to meet certain medical necessity, certain criteria for being gravely disabled by their mental illness.
And Mr. Thurman, if I may, a couple points.
Please.
One is this does not change the burden of proof at all for any of these.
Yeah.
It doesn't change anything about due process rights. It's about an investigation. And I will tell you, the people that you're referring to in your district, like all of our districts, they're touching the system already in so many ways. Homelessness, addiction. So this is one tool that will, as a practical matter, really only affect the severely mentally ill who will be seen in this. And it will allow it'll be one avenue, one additional small avenue that will allow an investigation to happen. Won't change any rights, won't do anything else as far as an ultimate determination, just an investigation.
Thank you, Mr. Chair, and thank you to the author. And I appreciate really the testimony in support and in opposition. And, once again, I do think we have to approach any conservatorship with caution, hearing that really what this does is create the opportunity for additional investigation. I still think that it is something worthy of moving forward in support. Thank you. Thank you all.
Great. Mr. Patterson?
Just a quick comment, Mr. Manchin. I appreciate the work that you're doing on this. I was a yes vote last time. I'm going to reluctantly just lay off, which means nothing except I appreciate your willingness, as was stated by Member Bonilla as well, to work through some of these circumstances. I'll reserve my vote for the floor. But I appreciate your work and encourage the continuation to work through the veto issues and some of the opposition concerns. And if it comes to the floor with that good faith effort, I probably can support it again.
Okay. Ms. Waldron?
Thank you, Mr. Chair. This bill is double referred, right? So it has to also go to judiciary, where a lot of the legal stuff will be hammered out. But so I think it's important that we move the bill forward so that all of those issues can come to light. But I'm looking right in the bill language, and it says that after a hearing by the conservatee, unless he or she waives presence, the Conservatives Council to recommend an investigation from the officer providing conservatorship if the court, in consultation with a licensed physician or psychologist, is specified, providing evaluation and intensive treatment.
Correct.
So it's not done without a physician or psychologist who's licensed.
Correct.
So I just wanted to make sure that was in the record as well. Thank
Great.
you.
Thank you. Anyone else? Okay. Well, Mr. Mainsheim, thank you for bringing this forward. I know this is a complicated and somewhat contentious issue. Are you confident? I mean, this was vetoed. So are you confident that the changes brought forward are going to satisfy the governor's veto message?
I hope so. I mean, I can't sit here and say, with any degree of certainty. I think we've shown, on this issue how hard we have worked on this, how many stakeholder meetings we've had. I think this is something that's important. I think that with the changes that we've made and kind of the steps that we've taken, I feel more confident about it.
Okay, great. Thank you. Well, my recommendation is support. We do have a motion on the floor and a motion and a second. The motion is due pass to judiciary, and I'll ask the secretary to call the roll.
Wood?
Aye.
Wood, aye. Mainshine?
Aye.
Mainshine, aye. Bonilla? Bonilla not voting. Burke?
Aye.
Burke, aye. Campos? Campos, aye. Chu? Tababne? Tababne not voting. Cooley? Aye. Cooley, aye. Hernandez? Hernandez, aye. Lackey?
Aye.
Lackey, aye. Nazarian? Nazarian, aye. Olson?
Aye.
Olson, aye. Patterson? Patterson not voting. Ridley Thomas?
Aye.
Ridley Thomas, aye. Rodriguez?
Aye.
Rodriguez, aye. Santiago?
Aye.
Santiago, aye. Steinnorth?
Aye.
Steinnorth, aye. Thurman? Thurman, aye. Waldron?
Aye.
Waldron, aye.
Your motion passes 15-0. Off to judiciary next. So that concludes the hearings. We do have some bills that are open. Everything has passed to their next committees, so we'll be calling out, asking for additional votes. So we'll go on to AB 1655. Mr. Dodd.
Hernandez? Hernandez, aye. Nazarian? Nazarian, aye. Olson? Olson, aye. Santiago? Santiago, aye.
AB 16, and that is that motion is now 18-0. AB 1668. Mr. Calderon.
Chu? Nazarian? Nazarian, aye. Olson?
Ms. Olson. 1668. That's okay.
Olson, aye. Santiago? Santiago, aye.
That is also 18-0. Moving on to AB 1696. Mr. Holden.
Chu? Nazarian?
17-1. Moving on. Ms. Atkins, AB 1795.
Campos? Campos, aye. Chu? Cooley? Cooley, aye. Hernandez? Hernandez, aye. Lackey?
Aye.
Lackey, aye. Nazarian? Nazarian, aye. Olson?
Ms. Olson.
Olson, aye. Ridley Thomas? Santiago? Santiago, aye. 17.
So that passes 17-0 with new seating assignments for Ms. Olson. Moving on, Ms. Bonilla, AB 1823.
Chu? Hernandez? Hernandez, aye. Nazarian? Nazarian, aye. Olson? Olson, aye. Ridley Thomas? Santiago? Santiago, aye.
So that's 17-0. And finally, Mr. Mainsheim. I think everyone was here.
Yes, except for Mr. Chu. But
Except for Mr. Chu, who is probably changing diapers still. Okay, at this point, we're going to go ahead and adjourn the meeting. And we still have 15 minutes in case somebody wants to add on to a vote, but we will stick around. We probably won't stick around for too much longer. Thank you very much. Much appreciated. Have a great afternoon.